First, we'll set the record straight, Your Lord. A couple of submissions I would like to make. I'll place before Lordship the written submissions placed before the Tamil Nadu bench and very specifically refer to 145. Because of the judgments of larger benches, which are dealt with the question of 200 and 201. So that's why, but then the judgment does not fully record the entirety of my submission regarding 145.2. So we are specifically referred to 145.3. The last paragraph, paragraph 11 of this, page 7, paragraph 11. Can you read it? Having regard to the importance that the scheme of Articles 200 and 201 play in the fine and balanced constitutional relationship between the elected legislature and the governor, it would be of utmost importance that the matter must be heard by a constitution bench, as already outlined above in terms of Article 145.3 of the Constitution. This submission is being made with a view the divergent perspectives available in the reading of so-and-so are reconciled, and the scheme of Articles 200 and 201 are duly delineated. In particular, the Constitution Bench judgment of the Honorable Court, Union of India versus Alluri Basavaya Chowdhury is kept in mind as the said judgment propounds one point of view as regards the process of exercise of duty by the governor in Article 200. You don't want anything more to persuade the court to go under Article 145. Now, let me try to, the 2G judgment has brought in very important perspectives on, I understand if Article 143 is not comparable to any of the other jurisdictions conferred on the court. It is the power and authority of the president. The authority and power of the president is not comparable to, say, 131, 132, 136, etc. They're all jurisdictions conferred to on the court. But the President, Article 143 says, if it appears to the President that a fact or a question of law is arisen or is likely to arise under public importance, the President is therefore the master of Article 143. And in the course of therefore requesting the court to give an opinion on this question, the court may dwell into the questions. The court may also go into any previous judgments of the Honorable Court and may either agree or disagree. But there's nothing like a threshold injunction against the court to say that we will not get into Article 143 reference at all. You can't read that limitation injunction in Article 143. And none of the previous reference, 15 references are coming for the court so far. Right from M.S.M. Sharma case onwards, Keshav Singh case onwards. The court has gone into previous judgments. But they may disagree or you may agree. So that's why in the 2G case, as the learned will talk to your lordships, the view of law, the state of law, and the decision. It is being told to your lordship that in this particular case, there is no demarcation, the lines are very, very blurred. Therefore, both are so intertwined that you can't entertain this 143 reference. I think that's not correct. Even if it is so, the question is whether under Article 143, what the court will do. To enter into the questions, answer a question, decline to answer a question, all that will be matter of practice or procedure of the court. In a given case, if a public importance, the court will say, we depart from the practice because it's an important question of public importance, and we'll probably look into the judgment 1, 2, 3, 4, 5. Therefore, there is no inbuilt limitation in Article 143, either that will bind the court under Article 143. Look at your old precedent, they are binding on you. 143 does not admit of any of those limitations. Therefore, what you could later argue saying this question need not be answered for good reason because some other judgment has answered it. That's a different way of putting it. But to say the court will not even enter into all of them, I think therefore 143 does not admit of that. I later place your lordship the very first important scheme of Article 143. I just thought, therefore I would say that given the importance in the scheme, in the constitutional scheme of Article 143, the court will probably, to repeat, can even depart from its earlier precedents and how the court will order its practice and procedure of deciding matters under 143. There's nothing like an inflexible rule. Then it will ultimately, if there's an inflexible rule, then the presidential referendum, the president being master of a referendum 143 will completely lose its essence. The court may ultimately say we agree with the judgment. But before that, to say you cannot even go to the extent of saying we agree, disagree, I think cannot be read into Article 143. Recovery water disputes brought is a very important distinction. The 2G notices that decision of law and then the view of law as against the particular a decree or a judgment inter partes. In a 143 reference, the court does not enter into merits inter partes. It's not a list between the parties at all. Parties can be heard in a 143 only for the purpose of assisting the court as to whether a particular question can be answered or not. Beyond that assistance, which parties can lend to the court under 143, the court will probably not say, I'll be heard on the maintainability. I think even the idea of maintainability is wrong in the context of 143. A maintainability issue can arise only when there is jurisdiction of the court. Article 32, 226, 131, review. Is it maintainable? If have you complied with all the preconditions of maintainability, then maintainability comes in. 143 does not fit to the concept of maintainability at all. I would therefore urge your lordships to be given all those 15 long precedents.
Right. Law or fact has a reason. That means a question of law that has not been answered in the past. Therefore, the question of law that would arise for 143 one will be the one which has not been answered by this court first. And therefore, that question is coming first time to be answered.
Yeah.
So 143 one jurisdiction will always be at least guided by this principle.
That's true. But therefore, 143 conditions, if you're satisfied, your lordships will go into entering into the question of answering those questions. So even if there is a field occupied by a particular judgment, but if the in public import, the president feels, I have a constitution bench judgment, I have a 7-judge judgment, I have a 3-judge judgment, I have a 2-judge judgment, which is the one which governs me. Therefore, on a question of law, if there is no authoritative pronouncement or a conclusive authority, the conclusive authority proposition laid in the Bala Sahib judgment, give that reference. Therefore, there is no conclusive authority in that question. And there is a difference of views, 7, 5, 3, 2.